done in furtherance of a game. And so I would ask the court, I didn't take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Am. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. If I'd taken this up before, I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to see clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, if they believe that's what the evidence will show. Okay?
They put it in their motion as...
Say again, ma'am? I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to...
Yes, ma'am, I would probably agree with you, but did I have a rule on that issue?
You said that you would do it later as it came
Okay,
out.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity for both sides. But do you have any other basis for the ruling? I mean, for my ruling, not any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that. But I didn't get that.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's
Love
your objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about...
Your Honor, they're a dump over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Adams.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that I'm not certain if this app thinks that we only serve 4. Maybe, I don't know if he had trouble opening it up, but we served, I think, all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I would share it if I did not, with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my theory, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. And no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we are supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether they're text is part of her opening.
All right, Mr. Matthews?
Yes, Your Honor. Good morning to the court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020 in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquette's view. And then we go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. in the state's opening presentation, the date they have is October 1, 2020. But in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
All right. Anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet, and I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also I'm looking at now, 48, 49, 53, 54, and 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court. As a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides you talking about, Mr. Steele again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so 48, 49, but then skipping to 53, 54, 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you.
His lawyers ain't come to play, that's for sure.
And he said, Mr. Steele, you get 45.
Just share the presentation, please.
Yes, Your Honor. Okay, so Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
All this underhanded strategy makes
All right.
it feel like a public hanging, not excluding whatever commission that took place.
53. Let's get down to 53. And 53 is what I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid. Some of them are embarrassed. Some of them are intimidated. Some of them don't remember. Some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witness is as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are there. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yeah, sure. I went over to the state's table. Carson Matthews and Gavin Juelz went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, Nate?
Can anybody spit a legendary Young Thug verse? Young Thug got
Folks,
some
this
good
is
music,
exactly why I
man.
told you.
I
want
can't
you,
personally,
and
but if
let
it
me
came
go ahead
on,
and
I
say
could
this.
sing
Like,
along.
I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. And the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
As far as any typographical errors,
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Matthews and Mr. Sharp have made are errors, and Ms. D. Williams need to be corrected. Okay?
yes, Your Honor, I will, of course, do it for the record.
But everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. We'll do it. And Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm going to tell them that. And I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Desiree, Sergeant Ingram, can we go ahead and call for our jurors, please?
Here we go.
You can go ahead and take up that during the recess, okay?
Yes, sir.
All right. Yes.
Told him to call him. Make sure y'all got a comfortable seat.
and gentlemen, please be seated. All right, members of the jury, we apologize profusely for the delay, but I got some good news. I'm going to send you a lunch. How about that? But the bad news is I'm not paying for it. So hopefully you all brought something or have made suitable plans consistent with the court's earlier suggestions to you. So what I'll do is at this point in time it's about 12:20, almost 12:25. I'm going to recess you until 1:45 to allow you to take comfort and take a big long stretch and get yourself something to eat. I would advise you from doing this a while, don't eat too much carbohydrate laden food because you will fall asleep, and then I'll be looking at you and have to embarrass you. I don't want to do that. So I just ask you to take that nugget of consideration from somebody who's been doing this a while, all right? But remember my admonitions I told you? Remember
no rice, no pasta.
If you decide to go out to eat lunch, remember you've got a time deadline you need to get back for, because we're going to try and call everybody out promptly around 1:45 or thereabouts and go ahead and get started. Leave your notepads in your basket if you decide to go out there, and remember all the admonitions that I've given you thus far, they apply to you and continue to apply to you. All right, so unless you have any other inquiry of me, ladies and gentlemen, I'm going to bid you a good lunch, and we'll see you back at 1:45, okay?
1:45, y'all.
All rise for a jury.